Hello and welcome. My name is Ed Lewis and I'm Head of Specialty Insurance here at Waitmans. Today we're bringing you a flash podcast reporting on the long anticipated judgment in the FCA's test case concerning the business interruption implications of coronavirus. Indeed, as many of you will have probably seen over the course of the day, media outlets have been reporting on what appears to have been a significant victory for policy holders. We're going to get into some of the detail of the test case in this podcast, but before I do, let me introduce you to my colleagues, Simon Durkin and Will Healy, who are both members of the specialties team here at Waitmans. Simon is a partner in that team and Will is one of our rising star associates. Simon, I'm going to come to you first, if I may. I think it'd be helpful for our listeners to have a brief summary of the full background to the case, even though over the past weeks and months, many I'm sure will have been picking up occasional sound bites and trying to follow the various media commentary that has unfolded. But we've got 6 weeks of history, at least, to this test case, and several months prior to that. So just set the scene for us, if you would.
Many thanks, Ed. Well, as our listeners will be well aware, a very large number of businesses have been severely affected due to the COVID-19 outbreak, particularly during the acute stages of the lockdown when many simply could not trade at all. The majority of those that had business interruption insurance looked to their insurers for cover, of course, only to be told in many instances that their losses were not covered because insurers never meant to cover circumstances like a pandemic. Now, before we delve deeper, I think it's worth noting that business interruption insurance will potentially cover loss of profits and additional expenses that an insured suffers as a result of insured damage to physical property, such as following a fire or a flood. But some policies also cover business interruption from other causes not related to damage, so-called non-damage BI extensions. In particular, infectious or notifiable diseases, I'll refer to these as disease clauses, and non-damage denial of access and public authority clauses or closures or restrictions. Also, I'll refer to these as denial of access clauses. Now, business interruption policies invariably also seek to explain how the insured's losses should be quantified by reference to the nature of the losses incurred. They also typically contain what are referred to as trends clauses to allow for business trends that would have impacted the business anyway had the matters giving rise to the insurance claim not occurred. In some cases, insurers had accepted liability under these policies containing such non-damage extensions. However, in other cases, insurers disputed cover, leading to a widespread concern about the lack of clarity and certainty. So the FCA therefore brought a test case with a view to obtaining certainty for policyholders and insurers in relation to such COVID-19 related claims, and in order to determine the issues of general principle on policy coverage and causation. The proceedings commenced on the 9th of June 2020 and were heard in July on an expedited basis under the Financial Market Test Case Scheme. This is a scheme which may be used for certain claims which raise issues of general importance where urgent legal guidance is required. Permission was given for the case to be heard by Lord Justice Flo and Mr. Justice Butcher sitting together. 8 insurer defendants agreed to participate in the test case. They were RSA, Argenta, MS Amlin, QBE, Arch, Ecclesiastical, Hiscox, and Zurich. The FCA represented the interests of the policyholders, many of whom were small to medium-sized enterprises. There were 21 sample wordings considered, but the FCA estimates that in addition to these particular wordings, some 700 types of policies across 60 different insurers and 370,000 policyholders could potentially be affected by the test case. Two action groups, the Hiscox action group and the Hospitality Insurance Group action, were given permission to intervene on behalf of certain policyholders and present arguments in addition to those presented by the FCA. Now, as you've mentioned, Ed, the High Court has today handed down judgment in the COVID-19 BI insurance test case. While the court reached different conclusions in respect of various sample wordings under consideration, based upon the court's findings, most disease and what are referred to as hybrid clauses, which we'll discuss later, and certain denial of access and public authority clauses appear likely to respond. The court also sided with the FCA on the question of causation as well as their interpretation of trends clauses. However, it is important to note that for the purpose of today's podcast, in light of the wide number of different wordings and issues involved, we can only really at this stage provide fairly high-level commentary regarding the court's conclusions, a number of which are really quite nuanced and highly specific to the wordings in question. So the judgment would or should be carefully reviewed for such detailed analysis.
Thanks, Simon. That's really helpful. So just a couple of points of clarification for our listeners. You talked in the outset there about business interruption cover for both damage and non-damage. We are focused solely, as far as the FCA's decision is concerned, with non-damage types of cover. Is that correct?
Yes, that is correct.
That's great, thank you. And you also touched quite helpfully on the fact that even though various media outlets are heralding today's decision as a significant victory for policyholders, the reality is the judgment is going to be quite a difficult one to interpret on a policy by policy basis. And indeed, it seems to suggest that there are a number of factual thresholds as well as fairly significant quantification exercises still needing to be gone through before any one individual policyholder may be entitled to a payout.
Yes, Ed, that's absolutely right. As is often the case, case by case analysis has to be carried out. Each policy wording will have to be considered on its own words, and indeed in the light often of the specific insured in question as well, for reasons which will become clear, I think, as we delve a little bit more into the details of the specific BI extensions that we're looking at.
These non-damage provisions, such as they are, that's really helpful. Thank you, Simon. So, Will, I'm going to come to you next, if I may. And Simon and I have obviously just been chatting about some of these non-damage provisions. I mean, the one that seems to feature most heavily throughout the judgment, and indeed is probably most commonly featured in the sample wordings under consideration, was cover for infectious disease. Can you tell us a little bit more about what the key issues actually were insofar as infectious disease cover is concerned?
Thanks, Ed. Yeah, absolutely. And I think it is fair to say that the infectious disease cover was the thing that occupied most of the court's judgment. It's 162 pages in total. So there's a significant amount of analysis of infectious disease cover across the entire sample of wordings. As Simon alluded to earlier, the case involves no less than 8 different insurers and 21 different wordings. So it's impossible to give a detailed overview of what the court said in respect of each one. But there are some common and key themes that did arise, and some principles that we can derive from the court's judgment. So in general terms, the court was grappling with the issue of whether clauses that provided cover for interruption to business following or depending on the wording used in a particular policy arising from or as a result of a notifiable disease occurring, or again, as per the terms of the policy, manifesting itself within a particular distance of the insured premises. So the insurers sought to argue that these extensions to the BI cover were only intended to apply to outbreaks of a disease in a specific location and not to a more widespread disease affecting the entire nation, such as COVID-19. The FCA argued on behalf of policyholders that there was no basis for this narrower interpretation, and they argued that cover would be triggered by the COVID-19 pandemic, as an outbreak in a particular area was an indivisible part of the disease as a whole, and or that there were a number of different effective causes of COVID-19 throughout the country. So two very diametrically opposed positions, but obviously the implications of one party being right and the other party being wrong would be enormous, bearing in mind that up to 370,000 policyholders in the FCA's estimation would be affected.
I mean, that's really interesting, Will. And when you put it like that, I guess many people reflecting would say, well, COVID-19, this pandemic, it's been local, it's been national, it's been global all at once. There seems to be some force in the indivisibility argument. But tell us, therefore, what did the court decide?
So the court, in large part, found in favour of the policyholders. And I think there are a number of factors that really influenced the court's decision. The wordings didn't specify, in any case, that cover would attach only in the event of an outbreak of a notifiable disease within a specified radius of the premises or within the vicinity of the premises. And so one of the aspects of the court's reasoning was that, well, it'd be anomalous for a disease to start off in clusters, eventually resulting in a national pandemic, and for that to potentially trigger cover, whereas a disease that occurs very rapidly throughout the country as a whole and results in a sort of a nationwide set of restrictions as opposed to a set of restrictions on a more local, granular basis. The court said, well, it'd be very anomalous for those two to be treated differently under a given insurance policy. And for wordings that provided for cover for outbreaks of an infectious disease within, say, a 25-mile radius of the insured premises, which was a very common formulation, the court emphasised that a circle with a radius of 25 miles actually constitutes an area of 2,000 square miles, or just under 2,000 square miles. So an area the size of Oxfordshire, Berkshire and Buckinghamshire combined. So I think that was another factor in the court's decision, because they accepted the argument made by the FCA on behalf of policyholders that if insurers were prepared to allow cover for any interruption to insured businesses arising from an outbreak of infectious disease in such a wide area, in an area of 2,000 square miles, they must have occurred to them that any actions taken in response might include governmental intervention. And I think they also made reference to the fact that many wordings expressly include diseases which are kind of pandemic in nature, such as the original SARS disease. And so it must have been in the contemplation of the parties. And I think more generally, the court seemed eager to avoid or prevent outcomes that it deemed to be absurd. So situations, for example, where the insured may have been in a better position from a coverage perspective if the government hadn't taken any steps whatsoever to prevent the spread of the disease. So by and large, the court's decision favoured policyholders.
Thanks, Will. And I guess, sort of just thinking about that logically, even if there hadn't been the occurrence of infectious disease within a 25-mile radius, if there had been a significant outbreak within a 25.1-mile radius, sort of the logical conclusion is that inevitably that outbreak will come near to the insured's premises in a very short space of time, such that if there were government action, it would stand to reason that action was effective action for the purpose of triggering cover. It, as you say, doesn't seem to be a logical result that the insured could be in a better position from an adverse or poorer reaction than that which we saw in this country. Tell us, therefore, just thinking about sort of tying up the threads, what further points to note are there, do you think?
Well, I think I mentioned a few moments ago that the court largely found in favour of policyholders, but there were two wordings, two of the QBE wordings, where the court actually agreed with the insurer's interpretation of coverage, and the difference in those wordings was that the infectious disease extension to the BI cover described the outbreak of the disease as events. And so the court took that to mean that the cover required there to be an outbreak of a disease within a particular area in order to attach. Because the term events in the context of insurance policy has a very specific and settled meaning. So I think for any other insurers who are looking at their own wordings and trying to decide whether and to what extent the judgment affects their wordings and the interpretation of the cover, it really underlines the importance of analysing the specific language and words and phrases used as the starting point. I think there's another point also. It was interesting to note that where the infectious disease clause, instead of specifying a particular radius from the insured premises within which an outbreak of an infectious disease has to take place, it uses the word vicinity of the premises. The court accepted that the term vicinity could extend to England and Wales as a whole in the right circumstances, because they accepted the argument that anything happening in England and Wales could have a direct impact on the insured's business.
I guess it's the scale of the impact that determines to some extent what the vicinity is likely to be interpreted as being. And if you have such, and I think this was identified in the judgment, but I remember Matt Hancock saying it time and again on the television. And if you look at the curve of the infection, if you look at the pattern of its spread and its fluidity, it was very much omnipresent nationally and globally, all at the same time, such that divorcing any particular location would have seemed highly artificial.
I think that's fair to say. I think there was generally throughout the judgment a thread running through it that some of the arguments raised by the insurers were deemed to be somewhat artificial and not really representative of what the court determined was the intention, the common intention of the parties when the policy was entered into. And the court was very, very keen to emphasise in parts of the judgment the artificiality of some of the consequences, implications of some of the points raised by some of the insurers.
That's great. Thanks, Will. Simon, I'm going to come on. I want to look at another one of these BI policy extension non-damage clauses that we often quite see, and indeed was a fairly fundamental part of the decision making today, and that concerns denial of access. Denial of access, of course, will be quite familiar to people in more recent times associated with problems arising from terrorism. But in a non-damage context, and particularly in the case of coronavirus, obviously not something encountered before. So tell us, what did the court have to say about the cover provided under denial of access or prevention of access or public authority clauses, as they're also sometimes known?
Well, denial of access or prevention of access, public authority clauses, as you've indicated, are provisions which provide cover where there has been either a prevention or a hindrance of access to or use of insured premises, and that prevention or hindrance has to be as a consequence of government or other authority action, invariably local authority action, action or restrictions indeed, and that has to be due to a life-threatening emergency, again within the vicinity, and that latter language ties in with your discussion with Will about that, on that very point, in the context of a particular category of disease extension. So the court considered, in the context of these denial of access extensions, a number of these types of wordings, and concluded in general terms that they were in fact related to specific localized events within the vicinity rather than the general national response to COVID-19, and therefore much narrower in scope. So very much akin to that QBE wording that you were discussing a moment ago. And as such, for cover to apply, the action of the relevant authority would have to be in response to the localized occurrence of the disease, and general action taken at a national level in response to the pandemic would not be sufficient to trigger cover. So in most respects, accordingly, the court concluded that there was no cover on these facts for most of these types of wordings. The court also was at pains to distinguish between actions, advice, and orders, which are words that these extensions may employ in granting cover. So actions, advice, or order of the authorities. And some of the announcements from the government, for example, were deemed to be advice, and didn't become orders or actions either at all, or at least until they were enacted in law. So cover would depend on which phrase the relevant extension adopts, and when certain things happened chronologically in terms of advice evolving into law. The court considered also that, subject to the specific language and specific wordings of the policy, if there was anything short of complete closure, there would be no prevention of access, but the position would be different where the cover was in respect of hindrance or disruption of use of premises, as opposed to the prevention of access to premises. And another interesting aspect of the court's consideration was that the type of business concern would also feature as part of the consideration of whether the order, etc., had prevented trade or merely disrupted it. So to illustrate this with a practical example, the regulations of the government on the 26th of March required sit-in only restaurants to close, but allow takeaways to continue to operate. So for those that didn't offer more than a de minimis takeaway service pre the 26th of March, the order would amount to a complete prevention of access, because it effectively prevented their businesses from continuing to operate. In contrast, a restaurant that offered takeaway services prior to the 26th of March regulations would only have its business partially impaired by the 26th of March regulations. So as such, in that instance, there may not be a prevention of access. So for this reason, two restaurants with exactly the same wording may have fundamentally different cover. So overall, a much more narrow, the court recognised that this type of business interruption extension for local authority denial of access provided much more narrow form of cover for insurers.
Thanks, Simon. And just finally, Will, I'm going to come back to you, because the judgment also touches on something that's referred to as the hybrid clause type. Just tell us what that actually means, and is there anything distinguishing those clauses from the denial of access clauses and, of course, the infectious disease cover that we've already talked about?
The hybrid clauses are kind of what they say on the tin. They're a mixture of two of the different concepts that we've discussed in the infectious disease clauses and the denial of access clauses. But they require there to be closure of the premises due to the actions of a public authority, due to the occurrence of an infectious disease. So if you like, there's kind of an additional hurdle that the insured has to jump over in order to access the benefit of cover. And the court's approach to those clauses was really just in line with the reasoning that they adopted in relation to those two foregoing categories. So any insurers whose wordings were not directly considered by the court in the test case would have to look at what the court said in relation to each aspect of their hybrid clause and to determine what level analysis, what type of analysis the court imposed, and then determine for themselves whether or not cover attaches.
Thanks. Well, that's really helpful by way of clarification there. Simon, coming back to you, when you were talking about the background, obviously you touched on, and indeed one of the great focuses in the debate prior to the FCA test case launching was upon the issues of causation, and in particular something called a trends clause. This had featured quite heavily because of a decision called Oriental Hotels and Generali, I believe. What can you tell us about what the court had to say today on the subject of trends clauses and causation, and indeed the Oriental Hotels case?
Well, as you've rightly mentioned, BI policies, and as I mentioned in my introduction today, BI policies typically contain these things called trends clauses, which allow for business trends that would have impacted the business anyway, had the matters giving rise to the insurance claim not occurred. Now, the operation of trends clauses was an absolutely central issue in this case. The upshot of insurers' arguments was that in assessing what business trends would have impacted upon the business anyway, regard could be had to aspects of the insured peril itself. I'll explain a bit more about this with reference to perhaps the best known illustration of this principle, and it's the case you've alluded to, being Orient Express and Generali. In Orient Express, the claim was for business interruption losses caused by Hurricanes Katrina and Rita. It was a claim under an all risks policy. All risk policies are ones where, to qualify for cover, the insured need only prove that it has suffered a fortuitous loss, and where appropriate, it's then down to insurers to establish that the loss falls outside the scope of cover by reference to one or potentially more often rather numerous exclusions. But in Generali, the trends clause incorporated a but-for causation test. I'll explain what was meant by this in a second. It also had a sublimited prevention of access and loss of attraction cover. It came before the court as an appeal from an arbitral tribunal. The premises in question in the Generali case were a hotel in New Orleans. There was no issue as to cover for physical damage to the hotel caused by the hurricanes. However, in relation to the BI losses, insurers argued that there was no cover because even if the hotel had not been damaged, the devastation to the area around the hotel caused by the hurricanes was such that the business interruption losses would have been suffered in any event. In other words, the insured could not show that but for the damage to the hotel, it would not have suffered the losses in question. Now, the court accepted this argument, finding that the necessary causal test for the business interruption losses had not been met because the insured peril was for damage alone, and the event which caused the insured physical damage, the hurricanes, could be set up as a competing cause or a counterfactual of the business interruption, i.e. the facts once the insured peril is removed. Thus, the narrower the insured peril, the larger the counterfactual trends to be allowed for in the context of the trends clause. Now, following this rationale, in the FCA case, insurers contended that the insured peril should be narrowly defined. By way of example, in relation to a disease wording, it was argued the insured peril was the local occurrence of the disease alone, and the other effects of the pandemic and associated government measures could be set up as part of the counterfactual as a business trend to reduce the claim. Now, if this were right, it would in practice mean that most payouts to insureds would be absolutely negligible. However, the court rejected this approach. It essentially decided that the trends clause is simply intended to put the insured in the same position as it would have been had the insured peril not occurred, where the policyholder has therefore, on the face of it, established a loss caused by an insured peril. It would be contrary to principle, unless the policy wording requires it, for that loss to be limited by the inclusion of any part of the insured peril in the assessment of what the position would have been if the insured peril had not occurred. In doing so, the court distinguished Orient Express on the basis that it was not concerned with the type of insured perils being considered in the current case, in particular the composite or compound perils featuring in the wordings that we've been discussing, contrasted with the all-risk nature of the cover in Orient Express. And the court also went on to say, albeit oversaid, that they saw a number of problems with Orient Express. In their view, the decision in Orient Express misidentified the insured peril by treating the damage to the hotel as the insured peril, rather than the damage caused by a covered fortuity, hurricanes, and the proximate cause of the loss was not damage, but damage caused by hurricanes. Thus, in considering the relevant trends, one had to completely exclude the wider damage caused by the hurricanes. Further, the decision in Generali resulted in the absurd result that the more serious the fortuity, the less cover was available. If the hurricane had only damaged the hotel, there would have been a full recovery. Accordingly, if it had been necessary for the case, they would have concluded that Generali was wrongly decided and declined to follow it. This is an absolutely fundamental part of the judgment, I think, because it's going to have huge ramifications for the way that these types of claims are dealt with in the future. Now, before I finish on this subject, I thought it might be useful if I just outline briefly the guidance provided by the court as to the in-principle operation of the trends clauses in respect of each category of the wording. So in relation to disease wordings, the insured peril is the interruption or interference with the business following the occurrence of the disease. Importantly, this included interruption via the authorities or public's response. So the wordings in issue ensured the effects of COVID-19 both within the specified radius and outside it, with the result that the whole of the disease, both inside and outside the relevant area, has to be excluded from the counterfactual. Prevention of access and public authority wordings, which we've been discussing, the insured there is a composite one involving three related elements. One, prevention or hindrance of access to or use of the premises. Two, by any action of an authority. And three, due to an emergency or incident which could endanger human life. So generally speaking, all three of these aspects must be stripped out of the counterfactual. And the hybrid wordings there, the insured peril is also a composite peril involving one, prevention of use of the insured premises, two, arising from restrictions imposed by a public authority, and three, resulting from the occurrence of a human infectious or contagious disease. So each of these related elements should also be removed from the counterfactual.
Thanks, Simon. That's a great analysis. Can I just ask you one point, one question, and a point of clarification, which I'm sure many of our listeners will be keen to hear you on also. A number of the policies, the notifiable disease clauses within those policies in particular, make reference to the requirement that there be an occurrence within a specified radius of the property, as you touched upon. So where we're saying now that the insured peril doesn't distinguish between occurrences both within and outside the radius, there must still be a requirement nonetheless for the insured to identify a particular occurrence within the radii specified.
Well, it's interesting you should ask that question, Ed. The court didn't make any findings of fact as to where COVID-19 had occurred. Strictly speaking, the onus will remain on insurers to prove on a case-by-case basis that the disease has occurred in a certain area, and that will need to be, as I say, determined on a case-by-case basis. However, I thought it was really interesting to note that there's seemed to be a general consensus that the categories of evidence put forward by the FCA, so NHS deaths data, ONS deaths data, reported cases, specific evidence as to the proliferation of the disease, they are in principle capable of demonstrating the presence of COVID-19, and also that a distribution-based analysis or an undercounting analysis, i.e. there are more cases than the reported cases, could in principle discharge the burden of proof on the insured. So, I mean, I think, and I hope this answers your question, the question of the prevalence of the disease and whether an insured has been able to demonstrate that there has in fact been an occurrence in its vicinity is I think unlikely to be a real evidential battleground in any future disputes.
Indeed, and I think this is probably the reason why I touched on the point that I did earlier about sort of those situations in which it might be said, what about an occurrence within 25.1 miles of a premises where the policy is subject to a 25-mile radius definition? Not least because I guess one has to consider the situation in which the occurrences aren't static. The occurrences manifest in the form of a person or persons becoming ill. And those people conceivably could move both within and without any specified radius at any given time.
Absolutely. I couldn't agree more. Okay.
Well, that's great. So where does this leave us then, Will, do you think, in terms of future implications? It's been suggested, I think, that insurers should be paying out to policyholders within 7 days. It sounds like a bit of mischief in the reporting to me, but how do things sit?
Well, I think financially the implications for insurers are huge. We said earlier that the FCA thinks that up to 370,000 policyholders might be affected by this, and if each of those policyholders is paid £10,000, which isn't unrealistic, to be honest. Once they've quantified their losses, bearing in mind the amount of time that this pandemic has persisted for, that's a total loss of £3.7 billion to the market. And those are the sort of figures that you tend to see for natural disasters, hurricanes over in the US, for example. But obviously, insurers will have set the premium and allocated reserves for those based on actuarial data. But I'd be very surprised if insurers had set aside that level of reserve for UK-based BI losses. So given that the stakes are so high, I think it's very likely that the insurers will appeal the decision. There's a procedure in place where the appeal can go to the Supreme Court directly, so it can effectively leapfrog the Court of Appeal, who would ordinarily be the next port of call. That's something that the parties are going to explore in further detail in the very near future. So we should have some clarity on that very soon. But obviously, if insurers need to pay up, then premiums across the board will obviously increase, and businesses and potentially individual policyholders in general will see an uptick in what they're paying for their renewals. I would also say that policyholders with other wordings will be emboldened to pursue claims with greater vigour now, and potentially insurers may see new notifications from policyholders who haven't yet submitted claims.
But wouldn't those claims be made too late now, Will? Hasn't the time passed for such notifications?
It's a good question. I think the answer to that is, if you look at the wording itself, then the answer to that is probably yes. But the FCA has set out its expectations for insureds, and I think there is a risk that certainly if insurers reject claims for late notification and there's a complaint to the FOS, there is a real risk that the FOS will side with the insured on that point, on the basis that there was so much uncertainty as to whether the claim would or would not be valid, that it was reasonable for the insured to wait and see what the court had to say about it. You also mentioned that there'd been some suggestion that insurers would have to pay out within 7 days. I think that you said perhaps that's a bit of mischief, and I think there's some truth to that, because obviously the claims won't have been quantified yet, and it won't be possible to quantify them in such a short space of time. The FCA guidance does say that insurers need to write to their policyholders at various stages throughout the life of the claim, including after the first instance judgment is handed down. So insurers do need to write to any potentially affected policyholders within 7 days to inform them of the implications for their claim. But it's not clear to me whether that means they need to pay claims now, or whether they're entitled to withhold payment until there's been a final resolution of the test case via an appeal.
I mean, presumably if payments are made out and then the Supreme Court, if indeed there is an appeal to the Supreme Court, overturns the decision, clawing that money back would be nigh on impossible. I suspect also a significant public outcry if businesses that have been in trouble for so long had received the money, suddenly were being asked to make recompense.
Well, exactly, and as you say, it's putting the risk, the solvency risk, onto the insurer, and there's every chance that that the money will be dissipated, and that there'll be no prospect of recovering the monies. So that is a real risk of if insurers have to pay out now.
Let me ask you this, Will. In the early weeks of the pandemic and the rejection of BI claims that we saw, in particular, there were one or two insurers that came out very quickly and said, very sorry, but our policies aren't going to respond to these claims. Obviously, a significant amount of reputational damage was done at that time, particularly for those insurers making those quite bold statements. Do we think that all of the insurers will want to pursue an appeal, irrespective of the legal merits, or do you think some may take the view that this is an opportunity to recover some lost customer confidence by throwing in the towel and taking this on the chin?
I suspect that will be a decision that each individual insurer will have to take, and it may well be driven by what their overall financial exposure is. And if an insurer has only got a very small exposure relative to others, then they may see that as a good opportunity for some some good PR. But by contrast, if an insurer is very heavily exposed, then I think they'd be much more reluctant to take any steps without actually having the final clarification from the Supreme Court.
I guess there's also a point, isn't there, about many of these insurers will be looking to reinsurers to stem the impact of this decision. It would be quite difficult, perhaps, to persuade those reinsurers to make recompense in circumstances where the opportunity to avail of an appeal wasn't taken.
Well, it's effectively would be treated by the reinsurers as an ex gratia payment, and I think the reinsurers would quite reasonably say we're not required to indemnify you if you're making ex gratia payments to your policyholders.
Interesting times indeed. One final question, Will, if I may, and I think this sort of is something which will be in the back of a lot of claims handlers' minds. Is there now a risk of damages being sought by policyholders for late payment BI claims?
It's a very interesting question and a very reasonable question to ask. I think the first thing I would say is that in order for a damages for late payment claim to succeed, the insurer does have a reasonable amount of time to investigate a claim. And I think any insurer facing a damages for late payment claim would say, well, we're in a situation where the actual legal liability for these claims was far from clear. And in fact, it was so unclear that the regulator felt compelled to bring a test case to obtain that clarity. So until such time as we have a final judicial decision on those matters, it's reasonable for us to withhold payment, and therefore we're still within the reasonable time to investigate the claim. I think that would be a fairly good argument, and I think a policyholder would be hard pressed to negate that argument. I think there's a further point as well, insofar as there has to be a causal link between the late payment of the claim and the loss suffered by the policyholder. And many of these clauses that we've been talking about today are sublimited to quite a significant degree. So it wouldn't be uncommon for a denial of access claim to be limited to 10,000 or 25,000, or for a disease extension claim to be limited to a 3-month indemnity period. So if you're looking at it on an individual claim basis, the indemnity to the policyholder in most cases will be somewhat limited, and for the insured to argue that the non-payment of a somewhat limited indemnity under the policy caused a particular loss, a particular financial loss, I think in many cases they'd be hard pressed to show that causal link.
Thanks, Will. That's really interesting. I guess watch this space to see how things unfold. I think undoubtedly, though, we will see claims being made, the waters being tested, and the pressure being heaped upon insurers. You talk about sublimits there, and I guess the losses suffered by many of the businesses that are holding policies which may now respond, nonetheless, will far exceed the limits of cover available. So late payment claims is a way to top up and mitigate that exposure.
Absolutely, and I have no doubt whatsoever that that's something that we will see being pursued by the claimant, policyholder, law firm community, and potentially also the brokers.
Well, there we have it. Really, really interesting decision today. Lots of implications, and quite clearly many twists and turns ahead, including a trip to the Supreme Court possibly later this year or early next year for the vast majority, if not all, of the insurers involved in the test case. It does, however, look this evening as if the future is a brighter one for policyholders, and I'm sure that as and when further clarification and insights are available, we'll be bringing those to you at the earliest opportunity. But for now, thanks very much indeed for listening. We hope you've enjoyed this podcast and that you'll continue to follow all updates in relation to coronavirus and its implications for the insurance industry at Wakeman's dedicated landing page to COVID-19. Thank you.